Okay, it is 10:01. Are we waiting on anybody else? Do we know of? I see the words here. Sam, can you turn your video on if you're able to? Awesome. All right, well, in that case, I'll call the meeting to order. Can we do a roll call of the board, please?
Chair Rose,
Here?
Member Laffey,
Here.
Member Pease,
Here.
Chair, you have a quorum.
Wonderful. I will entertain a motion to approve the agenda.
I move to approve the agenda.
Yep.
Second.
Okay, agenda's approved. Minutes for the previous meeting. I'll entertain a motion to approve those. Those should be attached to your agenda.
I move to approve.
And is there a second?
Uh.
Well, I'll second it.
Second.
Well, that'll pass through just consent. Moving to new business, we are here to discuss appeal number 2023-02. Before we start our deliberation, I will note for purposes of audience participation, although this is a public hearing, the board can only consider the record of the case below. So that's the briefs, the transcript, the record. We're not taking any testimony. We're not listening to any arguments. You can't make any comments. You basically just get to sit there and listen to us talk for however long it takes to reach our decision. There is a section on the agenda for audience participation, but that can't deal with this case. So when it gets to that audience participation point, if you have other things that you want to talk about, it's a public meeting. You're allowed to say those things at that point. So getting into our business of the day, then we're dealing with, as I mentioned, appeal number 2023-02. This is an appeal from two decisions made by the Planning and Zoning Commission last fall. We had already cleared any potential conflict of interest, but I'd just like to verify with each member after having reviewed the record and considered things. Did anyone discover any conflicts of interest that need to be disclosed? Hearing none, we will then go to consideration of the appeal. So I've done this a grand total of one prior time, but the way that we organized that discussion last time I thought was incredibly helpful. That's to have a motion on the floor and then discuss the issues one at a time. So my suggestion might be to kind of follow the confidential memorandum that our attorney cycled around, but I'll entertain a motion if either Member Pease or Member Laffey want to start the discussion on any particular issue. We can go to that issue.
I move to, and I also have been through a total of one in its entirety, one case in its entirety. So please bear with me too. But I move to consider this appeal in the matters of these Planning and Zoning Commission resolutions 2023-11, 2023-12, following the analysis laid out for us in our memorandum, which is items A through E.
Yep. On that motion to organize our discussion throughout those issues,
And I'll
is there-
second that motion.
Okay, and I'm going to assume there's no objection to that discussion, so that motion will pass just for purposes of starting. So then starting on our first issue presented, that is, and I'll just state the issue and then we can discuss within that. The first issue is whether omitting information in the staff report submitted to the Planning and Zoning Commission is a substantial procedural error. So for purposes of keeping this moving along, we need a motion either stating that it was substantial procedural error or was not substantial procedural error, and then we can discuss amongst ourselves. So I'll entertain a motion from one of the members to that effect.
This is Sam Laffey. I will move that the uninclusion of specific materials outlined in the appellant's brief was not substantial error.
Okay. And I'll second that motion for purposes of discussion. Mr. Laffey, would you like to speak to your motion?
Yes. So, and I apologize, my internet in Kenya is fairly limited, it appears, at this moment. Appears like the best way for me to connect through audio, so I've turned off the video for the moment. I will try it again in a minute because I would prefer very much to see everybody and have them see me, but I appreciate everyone's patience with this situation I'm in. So speaking directly to my motion, though, a review of the record, a review of the staff notes provided, a review of and several more reviews of the appellate record, it appears to me that very clearly the document that which the specific document that the appellant says was not included in the staff reports was in fact actually included. It was not included in the it was not included in the initial packet. It's not in the most of the staff reports and stuff that were provided and prepared probably 1 or 2 weeks in advance of the hearing, but it was added in a supplemental report, and that is in our appellate record clearly. And to make the record a little more clear, the appellant says that basically a resolution from their counsel was not included.
Okay.
And in my mind, this point is not a point of error for us to consider in the appeal, and my vote will be to barring information I don't have, I suppose, my vote would be to find that this is not a point of error for that we should consider any further.
Okay, Member Peace, do you want to speak on this issue?
Yeah, I have a little bit different take. I find that the record shows that there was a several months delay in transmitting the letter of the Bayshore Plat Community Council in the staff report, and that is a substantial procedural error. The received date stamp of September 8th compared to the date of the email that transmitted the resolution from May shows that it strongly implies that staff lost track of the resolution from the community council. The September 8th date stamp on the resolution letter to me indicates that staff did not transmit the letter to Planning and Zoning Commission before that date, the 8th, possibly not until the 11th, the date of the actual public hearing. Staff did mention the existence of the resolution to the commissioners, and they noted the opposition to the tower that the resolution spoke to, and also the other unresolved concerns of the community council. But they didn't address the substance or the particulars of the resolution or the delay in transmittal during the presentation of staff findings. The standard procedure is for planning staff to send a packet analysis along with written public comments in advance of the meeting, at least 1 week in advance of the meeting is what code suggests. And the opportunity, therefore, is for the commissioners to consider critical comments during their first fresh reading of the application. And presumably that's at a time when their impressions are still more malleable, their opinions still more formative. But the purpose of that being said, so I feel that was an error. However, the purpose of the public hearing is for additional public comment and questions and discussions. And that very forum implies that the commissioners are still considering evidence and open to persuasion. And the commissioners did have the Bayshore Plat Community Council letter in their possession at the time of the public hearing. And the president of Bayshore Council, as well as other members of the council and the homeowners association, engaged in robust and informative discussion with commissioners. So my thinking is that the error in transmittal of the resolution doesn't warrant further consideration by the Planning and Zoning Commission. In other words, it was mitigated or cured by the last minute or the late delivery of the letter, plus the opportunity and the actual exercise of robust debate.
Okay, so just to clarify, I think what your position is, Member Peace, is that you believe that there is a substantial procedural error, but that we, as the Board of Adjustment, can modify the Planning and Zoning decision to address that issue.
No, that we don't need to take any action, that the discussion at the Planning and Zoning Commission and the presence of the letter at the last moment, if we're satisfactory redress for the fact that the letter appears to have gone astray in transmittal. We do not know the details of that. We can't make any findings on that. But my point is that I feel that the discussion, the robust and two-way discussion at the public hearing itself, plus the actual physical presence at that time of the resolution, although late, was adequate to meet the purpose of allowing the community council to be heard.
Okay, so I think I know where the decision's going to go, but I have a question for Ms. Kitchen. On the procedure point of it, if we find that omitting these documents is a substantial procedural error, can we just affirm the decision of the Planning and Zoning Commission, or do we have to either remand or substitute our decision? Does that make sense?
Yes, and can you hear me?
Yes.
Under code, it allows you to determine, one, if there is a substantial procedural error, you can decide if the error warrants further consideration by the Planning and Zoning Commission, necessitating a remand, or if the board by majority vote can modify the decision to address the error. And here it's what I think I'm hearing Ms. Pease say is that there was an error, but this would be considered a harmless error, which at that point then you can identify it as a harmless error and move on to the next matter. But I do think if there is a substantial procedural error, you either have to remand it to the Planning and Zoning Commission for further consideration or modify the decision in some regard to address the issue. And maybe the modification of the decision is simply noting that there was an error, that the community council resolution was not included in the initial packet, but as Ms. Pease has stated, that there was a robust discussion about the matters brought up in the resolution.
Okay, well, I'm gonna throw a wrench in and make this my take on this is that it was a harmless error. I think I agree with Member Peace that it was an error to exclude the resolutions, and that obviously that needed to be in the initial packet. I think that the commissioners, when they get that initial packet, that's when they're most amenable to trying to learning anything they can about the controversy. And however, I'm convinced by looking at the transcript that more than one commissioner really challenged both the electric utility and then invited testimony from a number of members of the public, including the community council representatives, to really air out their grievances and really test those concerns. And it seemed like any error that did exist was cured by way of the testimony that happened at the hearing. That would be different if no one showed up from the community council, or that wasn't discussed, or no questions came from the commissioners. But that just wasn't the case. I think that the thoroughness of the questioning by the commissioners really shows that at least a couple of them were very concerned about the very same concerns that were raised in the resolutions. So my suggestion is that it's a harmless error. I guess that we can get some unity on this decision. I go back to Member Lathian's. Your initial suggestion is that there was no substantial procedural error. Would you be amenable to amending the motion to say that there was a harmless error? And if so, that seems to be the path of what might be least resistance, so we can get a consensus decision on how to resolve this issue.
May I chime in and ask whether
yes.
harmless error is a legal term that we must adhere to, or could we just call it an error that was remediated by the diligence of the Planning and Zoning Commission at the public hearing?
I'll give my
harmless error is.
Go ahead, Mr. Laffey.
In my understanding, a harmless error is a legal term that we should use to the advice of counsel to describe this. To call it an error would, I think, cause more problems later on than if there is an appeal, or if there is additional proceedings on this issue at some other body. I think it would be best to call it a harmless error. And to answer the chair's question, yes, I would be amenable to saying that we could consider this a harmless error, and that we are essentially this is a harmless error, and that follow the rest of the chair's logic, essentially.
So my take on this, and we'll get check me if you have a different opinion, Ms. Kitchen. But a harmless error is one where there is an error, but the fact that there's an error doesn't change the end analysis, because something happened that essentially cured that, or made it no longer affect the decision. So here there was the error, but it became harmless by way of the Planning and Zoning Commission discussing the very issues. That's what, in my opinion, makes it harmless. So I think that's a good layman's way to explain it. Yes, Ms. Kitchen? No, Ms. Kitchen?
I would agree with that analysis, and I do think, Ms. Peace, that there has to be either no error, a harmless error, or a substantial error. You have to use one of those terms legally.
Okay, thank you. I'm not an attorney, so I appreciate that explanation. And I was just concerned that by calling it a harmless error, it might be used as precedent in the future if resolution, community council input such as this is transmitted last minute, but I understand the definition, and it means, to me, what you just described is that the harmlessness was determined by the context, the outcome. So,
And there is a legal, from the Alaska Supreme Court, it defines, it suggests that an error can be harmless when it does not prejudice a hearing or affect a substantive right, then the error can be deemed harmless.
okay, thank you. I would make that part of the finding then as to why this is harmless.
And I would even go so far as to suggest when we issue our findings and conclusions to note that specifically to the Planning and Zoning Commission that we are concerned, because I think that that would be consistent, both my concerns and Ms. Peace's concerns, that there really does need to be a better job of making sure that the community council resolutions are included. That is a very important piece of the procedure. But we should, on the same hand, commend the Planning and Zoning Commission for seizing that and making sure that they aired those concerns, not just ignored them once it was there. So in my mind, it kind of it has that forward-thinking effect of what we would like to see the Planning and Zoning Commission do in the future when this sort of issue comes up again. Well, in that case, as my understanding and my kind of consideration of how I'm going to rule this Robert's rules is that Mr. Laffey's motion to consider issue number 1 as not a substantial error is amended by agreement that the non-inclusion of the documents identified in the appellant's brief, the community council resolutions, that was a harmless error. And if there's no other discussion on that, we will go for a vote. So a yes vote is that the non-inclusion is a harmless error. A no vote would continue discussion on the issue. Would you call the roll, please?
Member Pease,
Yes.
Member Laffey,
Yes.
Chair Rose.
Yes.
Passes 3-0.
Okay. So resolving that issue, I will entertain an issue on, or a motion on the second issue.
I move that let's see, that the Planning and Zoning Commission's finding, does this need to be stated in the affirmative?
You can say it in the affirmative or the negative.
Okay. I move that the Planning and Zoning's, that the community meeting summary okay. I'm looking at my notes and I'm looking at the way that it was presented to us. So I'm struggling a little bit, but I'll just try it in kind of spontaneous language. That the community meeting summary did not meet the adequacy standards and therefore is a factual error. Or I could say it, if I may restate it, using Ms. Attorney Kitchen's language. I've moved that we find that the Planning and Zoning Commission's implicit factual finding that Chugach met the Community Council meeting requirements in 2103-020 is supported by substantial evidence is an error.
Okay.
I will second that for the purposes of getting discussion rolling. Thank you, Member Peace.
Okay. Member Peace, would you like to speak to your motion?
Yes, the community meeting summaries were represented in the packet. There were both March and April meeting summaries. It's clear from the meeting summaries that the meeting did not present, that there was a lack of detail, including renderings of the tower, fence, or landscaping. In fact, the fence and the landscaping were not even raised at all. The March and April meetings didn't disclose that the developer intended variances that would not meet the standards for L2 landscaping. And under 2103-020C1, the purpose of community meetings is to inform the surrounding area residents and property owners of the details, and I'll emphasize details, of a proposed development and application, and also how the developer intends to meet the standards contained in the title. And I feel that the community minute summary, meeting summary, falls or does not demonstrate that the details were transmitted, that the application was explained, or how the developer intended to meet the standards was explained. And because this is a conditional use that included variances, the variances in particular should have been disclosed at the community meeting or in a follow-up, because the Chugach Electric pledged to bring the completed application to the community council. There are minimum requirements for a summary of a community meeting, and staff, I think, is obliged to make sure that the summary includes those, the substance of concerns, issues, and problems, how the applicant has addressed or intends to address them, and concerns, issues, and problems the applicant is unwilling to address, and why. And in the case of the variances were not mentioned. The Chugach Electric had a plan for how not to meet the screening requirements, and that wasn't presented. So I feel that the community council was ill-informed and then told to wait for more information, which was not provided. And so that really, I believe, put them at a disadvantage. The intent being early dialogue and back and forth to reach a compromise or a compatible, consensual resolution, and that really can't happen at a public hearing. So I think the community meeting purpose was not met, and the summary was inadequate. The staff should have understood that the community meeting had fallen short.
Okay, thank you, Member Peace. Member Laffey, would you like to speak to this motion?
Thank you, Mr. Chair, and thank you, Member Peace. I kind of have an idea about where I would go with the remaining three, but for this one, or the remaining 3 points we're going to discuss later. But for this one, I was kind of, can everyone hear me, Mr. Chair?
Yes, yes.
Okay, sorry. But for this particular issue, I'm unsure where I stand even now at this, in all honesty. On the one hand, remember, on the one hand, I tend to think that that efforts were made, and that I think a lot of the conjecture that the appellant outlines in their brief, I'm not sure that's all in the record. It's in their brief, but I'm not sure that's really in the record, that would really be able for us to consider. On the other hand, I am sympathetic towards the appellant's brief, in the sense that, at least according to them, Power Authority essentially didn't follow the proper procedural guidelines, and really seemed to just pass the buck and say, well, this all can be discussed at a zoning meeting later. That's when you should ask questions, and that's when we'll have a lot more information. Now, there appears to be like a 6-month time lag between when they said that and when the zoning meeting happened. And the record really isn't clear about what happened in that intervening time, as best as I can see. It's kind of silent about whether or not there were additional attempts, as best as I can see. So I don't know. I don't know where I really sit on this. I'm kind of leaning towards this is more of a harmless error, if it's an error at all, in all honesty.
Let me share my thoughts too and weigh in on this. I share the same concerns, and I was curious where in the record we can point to. Well, let me back up a minute. I think that there are, as Member Peace outlined, a number of items and points that the utility did not do in their meetings with the community councils. And what I find most problematic is the possibility that there had been a promise to come back later with, the final design and continue to follow up in discussion, and then that never happened. There's what appears to be allegations between the briefs of whose fault that was, whether that was, the utility tried to and the community council wasn't meeting, or the community council offered. That we don't have the information in front of us of exactly how that went down. But we do have in the record the summary that was written up, and this is in pages 86 through 88 of the record. That did include the intention and promise for Chugach Electric to come back. And I'm looking at record on page 88. The question, and this is maybe 4 lines from the bottom, the question from the community council: do we get to see the final draft? Parentheses, conditional use permit application. CEA response: we plan to coming back once everything has been finalized. Community council question: what does the process look like? If you show us our final plans, we object. What happens next? CEA response: as I mentioned before, when we have the final plan, we will come back and present to the community council, which suggests to me that at least in that process and procedure, there was still discussions that had to happen in coming up with a plan. And it doesn't look like that final plan was actually discussed in front of the community council until we get to the actual planning and zoning commission hearing, which I agree with Ms. Peace that is not really the time to do that. There's a reason that this procedure exists. There's a reason there has to be community involvement and chances for the community to weigh in on that. And it seemed like this was, for whatever reason, it didn't happen. I don't know whether that was the utility's fault. I don't know whether it was the community council's fault, but I don't think it matters, because in my mind, that's a critical piece of the procedure that wasn't followed. So my take on this, and I know that we have other issues to discuss, but in my opinion, generally speaking, I think this is the most significant error. Now, that leaves us kind of with what to do with it, because this is for the decision of the Planning and Zoning Commission to stand, a necessary factual finding they have to make is that Chugach Electric had met the community council meeting requirements that are spelled out in the code 21.03.020. And it's mentioned in our brief as an implicit finding I suppose it's helpful to go back through and look at the actual specific findings of whether that was specifically found by I don't see a specific finding. I think it's just implied in the findings that it had met the community council meeting requirements. But my understanding, and this I'll get from Attorney Kitchens, your take on it, I think that as a factual finding, even if it's an implicit factual finding, we can only reverse that by unanimous vote.
That is correct.
Okay. So only if all three of us find unanimously that there is an error, can we reverse a factual finding. What we do with that is, I think, another point of discussion, because I think we don't have to correct me if I'm wrong. I'm still memorizing the rules on this. We can either remand back to planning and zoning for consideration of the issue, or we can substitute our judgment if we have unanimous agreement to do that. Is that right, or am I missing a step?
That is correct.
Okay.
Yeah, through, I probably should be saying through the chair, through the chair.
No, you're good. Please go ahead, Ms. Pease.
The other point I wanted to take note with was from page R84. When a question was asked at the first community meeting why Chugach had not provided a rendering of what the tower would look like. And Chugach Electric's response was they were trying to prevent information going out to the surrounding residents that would later have to be redacted because of potential changes occurring during the design and permitting. And to me, that belies the whole purpose of a community meeting. It's expected that there will be changes as design and permitting goes through, but to not show your starting point really, I think, puts the community at a disadvantage. And that was with regard to the tower, but the same is true for the landscaping and the wall, because nothing was presented on those topics. So that's another area where I feel the applicant Chugach did not meet the community meeting some purpose, and the Planning and Zoning Commission staff didn't, take objection to that or take note of that.
I remember reading that. Okay, it's in the middle of the page on 84. I
Yes.
see that. Okay. Okay. Well, it sounds like, just based on our comments, that Ms. Pease and I are probably in agreement on the error and the need to reverse. Mr. Laffey is kind of on the fence on it. Maybe, and not to put you on the spot, Mr. Laffey, but maybe put what concerns do you think still need to be addressed before you're ready to vote on that issue, I guess?
I don't think any concerns at this time, Mr. Chair. I'm ready to vote. I agree with you and Ms. Pease after, particularly after seeing your both citations just now and taking a gander at them. It looks like my notes are a little bit mixed up. So my suggestion would be we remand the decision back to the zoning board.
Yeah.
So that way the Chugach Electric can figure out what they need to still do, if anything, with the community council, and planning and zoning board can consider, if they want to, our ruling in an immediate fashion, essentially.
Right, so what we do with it in terms of a remand is the next question we'll ask, but I think your head's probably going the same way that at least mine is. Let's go ahead and call a vote then
Yeah,
on,
but before we call the vote, I
Yes,
note that we are supposed to have substantial evidence. So I would just add that the substantial evidence includes the detailed discussion and testimony of concerns about the visual impact of both the tower, and the landscaping that were presented at the public hearing, and the applicant, those could not have been raised at the community meeting because the community didn't know about them. And so the community had no way to know how the applicant would address or intend to address them.
Excuse me, Chair Rose, this is
Yes.
Courtney. I just want to, so the motion that we have is the find that the Planning and Zoning Commission's implicit factual finding met the community council meeting requirements is error. And I would suggest that we, as Ms. Pease just noted, that is amended to note to either in the affirmative or in the negative that it is supported by substantial evidence or it's not supported by substantial evidence. And that I want to note that it has to be, if you find that if you're not going to defer to the Planning and Zoning Commissions on this implicit factual finding, there has to be unanimous vote to substitute your independent judgment on it. And then I think once that decision is made, we can then, because the community council meeting is a procedural requirement, then we can talk about what the remedy is and whether we even need to address the remaining issues. But I think restating the motion might be helpful legally.
right. So I'm going to suggest, and Ms. Peace, you're the maker of the motion, so if you adopt it as the amendment is friendly, that'll work. But I'm going to suggest we state it in the affirmative, which is that the Planning and Zoning Commission's implicit finding that Chugach met the Community Council meeting requirements in AMC 21030220 is supported by substantial evidence, would be the motion, and then we can deal with the ramifications of that vote afterwards. Is that adopted as a friendly amendment?
Yes.
Okay, so a vote, we're going to call the vote then. A vote yes would have the effect of affirming the decision by the Planning and Zoning Commission, stating that their decision is supported by substantial evidence. A vote no has the effect of reversing that decision. We call the roll, please.
Chair Rose,
No.
Member Laffey,
No.
Member Pease,
No.
Okay. So we unanimously voted no on that, which leads us then to the question of what to do with that issue. We don't have a motion on the floor right now, but I know Mr. Laffey had mentioned a moment ago the idea of remanding, so maybe now would be a good time for a motion, then we can discuss that. Mr. Laffey? Member Laffey, I'm sorry.
Thank you, Mr. Chair. Yes, I would move that the board remand the issue about whether or not there was substantial, essentially due process given to the community council, to the Planning and Zoning Commission for further review. And I would add to that motion that the Chugach Electric should be required to present again to the community council.
On the wording and the proper procedure, Attorney Kitchen, any concerns, or does that seem to be all right?
I think that the board, it sounds to me that the board has found that there was not compliance with the community council meeting requirements, that implicit finding that by the Planning and Zoning Commission is incorrect. So I think a motion needs to be clear about whether it's remanded for the Planning and Zoning Commission's further consideration or for the community council to present again and comply with the code requirements on public meeting. Because it sounds
Attorney
from what
Kitchens,
it sounds from what the board has decided that Chugach Electric has not complied with the community council requirements. And if that is the case, they need to comply with the community council meeting requirements in code.
So is that a directive that we give, or does that reversal just put the ball in their court and make them have to do it themselves?
The code requires the board to give direction on remand, and so there has to be direction given about how to resolve that incorrect factual finding.
Okay.
And this is another kind of tricky thing, because there was a factual finding, but the fact that the board disagrees with that factual finding brings up a procedural error then, because code requires the community council meeting as part of the procedure for conditional use applications.
Right.
Mr. Chair, my problem is, if this is a substantial, I'm looking at Ms. Kitchen's memo, we should remand the case to Planning and Zoning Commission where there is a substantial procedural error that requires further public hearing. But I'm just not sure what the purpose of a public hearing would be if the rest of the decision is held, is confirmed. So do we come back to this after we consider the other points of the appeal, or a public hearing if the rest of the I don't need to repeat myself.
Yeah. Yeah. I mean, we could table it, but I think we should deal with it now. The other issues presented, typically, if there's an issue presented, a further hearing is all that's sufficient to cure that if it's on a remand. But this one is an error in the procedure before the actual hearing on the Planning and Zoning Commission. So the only way that Chugach Electric could cure that, if they wanted to continue to seek this this approval, would be to essentially start again at the community council level. So I think that's kind of what we're trying to get to, is the language. Let me take a stab at motion language and see if this works for everyone. I guess I should. I'm trying to come up with a good way to say this. Give me just a second. Due to the error in Chugach not meeting the community council meeting requirements, this board instructs CEA to fulfill those requirements as part of their conditional use application. I don't know. I don't think I like the wording of that either. think we're all trying to say the same thing.
So, Mr. Chair, when, this is not a remand, is that correct?
It essentially, that's a really good question, because we're not asking the Planning and Zoning Commission to reconsider based on what exists already. We're not asking them to have another hearing. We're essentially telling Chugach Electric they have to start the community meeting process over again. Whether
Right.
that's considered a remand or just reversing the decision.
Which I,
Yeah, which, but what I understand is I don't know that we have the power to just reverse. I think that we have to give directive.
We do, we're not giving, in the wording presented, we're not giving direction to the Planning and Zoning Commission, we're giving direction to the applicant.
Right.
And I don't know if we're allowed to do that. And
Right.
one more thing, just, this is a minor, but it's Chugach Electric. I think it's important to state these names correctly.
well, what we should do then, since we can't really order the community council or the appellee to do anything, we could just order a remand until such a time as a community council, until the community council and the appellant can meet and comply with the code, essentially. Because I think there's no, if since we are rebanding, I think there's no way we can't have, unless we're outright throwing everything out. I don't think we can get around the fact that the Planning and Zoning Commission would have to re-meet and have another hearing about this with public comment, and it would have to be substantially, very likely they would have to go through the same procedure as before at their prior meeting, essentially.
Okay.
That's kind of
Right.
that's kind of where I'm at here.
How about this? We remand to the Planning and Zoning Commission for further hearing and direct the Planning and Zoning Commission to require the community council meeting requirements be met before they reconsider this issue on remand. So
I think
that go ahead.
Yeah. No, you continue. I agree so far.
Yeah, so, and I think that keeps our focus on remanding the decision and giving a direction to Planning and Zoning. Then we put it in Planning and Zoning's hand to schedule their own commission meeting after Chugach Electric goes through the additional meetings they have to have with the community council or community councils, and should resolve the issue.
This is Courtney Kitchen. I think that is legally makes sense the way that is phrased, because also you can remand if the Planning and Zoning Commission committed a legal error, which in this case, because there wasn't proper procedural compliance, that could be deemed a legal error too,
Right.
I believe. So, and I think, to be clear, if the board remands on this issue, I don't think that we can get to the remaining issues.
That actually was something I was thinking about too, and I'd like to hear.
Attorney Kitchens.
Go ahead, Mr. Laffey.
I'm sorry, the internet broke up right when Attorney Kitchens was talking for me. Could you repeat what you said about the remaining issues, please?
I believe, because if you're going to remand to the Planning and Zoning Commission, finding that there was an error the procedural error that requires a remand and adherence with the process for conditional use applications. I don't think the board can consider the rest of the issues, and I'm happy to discuss that too, because this is not something that we have thought about or addressed in the past, but I think that the procedures are in place to inform the board, to inform the Planning and Zoning Commission in their decision-making process. And I think if we affirm or reverse any of their factual findings about the actual applications, it moots the procedural issues that have been, that have failed to been met, is my thinking on it. But I'm happy to
Yeah,
consider other information as well, but that,
let's workshop that one for a minute. So this is because it's a procedural error. And we applied this standard as if it was a factual finding and reversed the factual finding, but the implication is really it's a procedural error. So really the effect of the vote that we had challenges both the procedure done and the factual finding, or the implicit factual finding that the Planning and Zoning Commission had made. So the question is, if there's a procedural error, does that mean that it's unnecessary for us to even consider the other issues? Or should we consider them anyway? And if there are other errors to discuss, other issues, does it make the most efficient use of time to present all of our issues to the Planning and Zoning Commission so that we're not back again in, however many months it takes dealing with these other issues that are still unresolved? I guess that's the question. And if we have the discretion to look at those other issues, my suggestion is that we at least entertain them now. If we don't even have the discretion because the procedural error exists, then I don't want to run afoul of what our jurisdictional power gives us. And I apologize if I'm speaking on a legal level too much and not bringing it down to more layman terms, but that's where my head's at on it right now, at least. Ms. Kitchen, any further thoughts there?
Yeah, I'm trying to review code right now too.
Well, while you do that, I think
Mhm.
I think we have this motion on the floor right now that I had phrased, and I didn't write down the wording. Did anyone write down the wording of it? We can have that. I thought it was very, very well worded when I stated it. So, could you read that back, and then we can either discuss or have a vote on it.
Through the chair, you move that the board remand to the Planning and Zoning Commission for further hearing and direct that the Planning and Zoning Commission to require the community council meeting requirements to be met before they reconsider the issue on the remand.
Okay, so I think that's well within our power to do, and I think that that's probably consistent with what the three of us would vote for. But do either of the other members have discussion on that motion before we vote on it? No.
No.
Okay.
No
Well,
discussion, and I'll formally second it.
Okay. Let's go ahead and call the roll on that then, please.
Member Lackey.
Sorry. Let me specify. So a yes vote on this motion would remand the decision to the Planning and Zoning Commission with the instructions that are detailed out. A no vote would not. I'm sorry.
Member
To
Lackey.
repeat my vote, yes.
Member
Yes.
Pease.
Yes.
Chair Rose.
Yes.
That passes 3-0.
Okay. Did that buy you enough time, Ms. Kitchen?
Yeah, I think that I don't think the code, well, okay. In section, Anchorage Municipal Code 21.03.050, 13, it might be let me look, A13, it talks about remand decisions. And remand decisions are, if you remand to the lower administrative body, the board shall describe any issue upon which further evidence shall be taken and shall set forth any further directions the board deems appropriate for the guidance of the lower administrative body. So I think that that motion has done that now. I certainly think that the board can consider, there's no, it's ambiguous whether the board should continue at this point with determining whether the conditional use permit criteria were met and the variance criteria were met. I understand the idea that if it's not discussed, it might come right back to us. But the whole idea of the procedure is to set up the Planning and Zoning Commission with the information necessary to make decisions. And it seems like remanding for the Chugach to adhere to community council meeting requirements, but then if the board goes ahead and either affirms or reverses the decision about the conditional use permits and the variance, that is not giving, it's not letting the procedure play out in a way that would allow the Planning and Zoning Commission to make a decision based on that new information.
Yeah.
That's my concern. The code is not clear on this, so
It seems to me on that, and Ms. Peace, I'll continue in a second, that if we continue to consider the other issues, we are in effect almost ignoring the fact that the procedural error existed. And instead, we should stop our consideration now. We might, and I think the recommendation that I'd make would be for us to, include an additional directive to the Planning and Zoning Commission to take a hard look at the arguments that were presented in this appeal that we are not yet getting to, so that maybe they can try and address some of those at their level before it invariably comes back to us on appeal. But I think you're right in terms of a legal analysis. We should not consider factual issues given what is a procedural error. And if we were to consider the other issues, any rulings that we would make on those other issues would be functionally inconsistent with what we just did.
it would moot the process.
Exactly, whether or not we agreed with the appellant or the appellee, it risks inconsistency, which we shouldn't have. So that's my position on it. That might be within my discretion to decide, but I'll certainly hear other discussion on that if the other members have other concerns with that.
Yes, through the chair, I have more of a question. If we do not take any action on the approvals of the conditional use permits, can Planning and Zoning Commission satisfy our direction about the procedural error just as a pro forma step, and without reflecting, presumably the community meeting will produce another round of dialogue and possibly additional solutions, what obligation is the Planning and Zoning Commission under to consider those solutions if we have not taken any action on the approved conditional use permits that the currently approved conditional use permits?
Right, yeah, that's a really good question. So right now, and Ms. Kitchen, I'll ask you to chime in on my analysis here. Right now, there's a decision that was made by Planning and Zoning. We are saying in our remand to them that decision failed to follow proper procedure. Because it failed to follow proper procedure, the factual findings that they made really are void, and they need to make new factual findings. When they, in the future, make new factual findings, after this procedure is hopefully followed by them, that's a new hearing. Those are new factual findings. That's a new discussion that takes place. And if those factual findings result in an appeal back to this board, that's essentially a new appeal for us to consider at that time. My hope, and I think we should include an instruction to the Planning and Zoning, that they also consider the issues that were presented in this appeal that we're not getting to, so that it can, hopefully, we don't have to have an appeal on the future, but we might, and but that'll be limited to what happens then. Is that kind of an accurate statement of where things are, Ms. Kitchen?
I agree. Mhm.
So through the chair, we don't have to take any action to find that the factual findings in the remaining issues related to the 2 approved conditional use permits are void. We don't have to find them void, but we have implicitly found them void. Is that what I'm hearing?
That's a good question. I think that we can include that in our conclusions of law. When we have the document that gets drafted up and we meet again. And that would be my suggestion, is that is included in those conclusions of law, that by way of finding the procedural error, any of the findings made by Planning and Zoning are void by application of that law. So the Planning and Zoning Commission needs to make all their findings again when this condition, when it becomes appropriate for them to have their next hearing. So I don't know that we need to vote on that. I think it's just an application of the decision we made, which ends up being in the conclusions of law, and ultimately the wording of that we can wordsmith in a couple of weeks when we meet again, or next. I don't remember when we planning on meeting again off the top of my head, but when we have that in front of us, we can certainly wordsmith that. So my intention is to make that ruling from the position of the chair, is that the rest of the issues are unnecessary for us to discuss. But so that we make the record clear on this, if either of the members have objection to that, please so state, or we can call it there for the day.
Mr. Chair, this is.
Oh, sorry, Mr. Laffey, yes.
Member Laffey, yes. I don't have an objection. I looking at and considering about what to do with the remaining 3 points of appeal. I think if we ruled on those today, essentially, we would be making our, we would be really just substituting our opinion for the Planning and Zoning Commission. And either way, we're kind of undermining whether or not the process should happen again, which I think is the consensus of the board with what we decided with the second point of appeal. That the community council and the utility company need to have another meeting, and that realistically this needs to be reconsidered by the Planning and Zoning Board afterwards. I think if we make rulings one way or the other on the other 3 points of appeal, well, one, we rule one way, there might not be much of an incentive for the community council to engage, or there might not be much incentive for the utility company to engage any more than a pro forma sense. I think it would be much better for the parties that have disagreements to have a open and honest conversation without these decisions, in all honesty. So I support your suggestion, Mr. Chair.
Mr. Chair, I have one other question. Some of my analysis on the remaining issues focused on whether the planning staff analysis was based on adequate evidence. Is there any benefit in discussing this further for the further decision-making of planning staff? Or is that not anything we should raise?
Right. And my thought on it is it's a moot point, right? If there's other procedural issues that happened, then we're gonna have a different record in front of us the next time this case is up on appeal. And those things may or may not happen. We don't know, through kind of negligent error or any other reason. So it's a moot point for us to kind of discuss any of that, in addition to the concern that I think I raised before, which is the inconsistency of decision, of the applications of our decisions. So that's a fair question, but I think it's more appropriate to look at the record of this case the next time it's appealed based on what happens in that next set of procedures and appeals, assuming that it gets appealed. I mean, maybe this goes back to the community. The hope of this board is that this goes back to the community and that the community councils and the electric utility are able to work everything out and that everyone finds a solution that's workable. And I mean, that's what these procedures are all about in the first place and what the hope of this board is. There's always going to be some degree of disagreement, but hopefully it's not sufficient to the point that it needs another appeal. So with that said, I think that'll just be the ruling. And with respect to the issues on appeal, the remaining 3 issues that are presented in the appeal, the board is not considering. And we will specifically put, I think, in the conclusions and findings that we reached our decision and did not consider those other issues, but that the Planning and Zoning Commission should at least be mindful of and take a look at the issues presented when they consider the case again.
Chair Rose?
Yes.
I have 2 suggestions that might help clarify, just for the record. One, I would suggest that the board makes a motion and votes under Municipal Code 2103.050A13 to remand the case either to say that there's been a substantial procedural error that has occurred or to say that there's been a legal error. And I think that more fitting is if the board can vote to determine whether to say, not that there's just been an error, but there's been a substantial procedural error. I think that those using that terminology will be important. And then also to address Member Pease's concerns about the other issues we're not addressing in a decision in the board's decision. You can specify that the Planning and Zoning Commission's findings regarding the conditional use permits and variance must be supported by substantial evidence. I think that might direct them to some of the concerns that Member Pease has, which it sounds like there might not be substantial evidence.
Well, as to the first point, I will make that motion, then I'll move that we remand to the planning and zoning due to a substantial procedural error as per AMC 21.03.050 alpha 13. And I think is there a second?
I'll second that.
Second.
Yeah. I'm looking to try to see what that one is. I had mentioned also 2103.020C6D summary of community meeting.
Yeah, and I think this is the citation on our authority to remand for what is called a substantial procedural error. And I think we've discussed it at length. I don't know that we need to discuss further, but if anyone has any other discussion on this motion, feel free to chime in, or we'll just go to a vote.
Okay, Mr. Chair, could you repeat the code citation that?
Yeah,
is-
that's
is-
that's 2103.050 alpha 13.
Oh, 50 alpha 13?
Yeah, A13.
Okay, got it. I'm just looking right now. Okay,
I try to use the radio
Yeah.
call signs when I can
Okay.
remember them.
all right. Very good, thank you.
All right, hearing no need for discussion, we'll just go straight to a vote. Would you call the roll, please?
Chair Rose,
Oh, sorry, let me specify. I tend to forget this. So a vote yes would remand to the Planning and Zoning Commission on the basis of substantial procedural error. A no vote would not. Thank you.
Chair Rose,
Yes.
Member Laffey,
Yes.
Member Pease,
Yes,
Okay. And then Attorney Kitchen, your second recommendation was to direct the Planning and Zoning Commission to, and that's as much as I wrote down in my notes before I got sidetracked.
That their factual findings must be supported by substantial evidence. And
Oh.
Ms. Pease, we can certainly include in the decision your reference to the specific code requirements that weren't met with regard to the community council meeting, and that would be with regard to the factual findings. So I think we can address both of those.
Right, and I think that at least with respect to the kind of the list that Member Peace mentioned when we were discussing the second issue, I think that's very helpful for our factual findings to go through those details, and I think that's included in the unanimous vote that we all took afterwards. With respect to any of the other issues that we have not yet discussed, I don't think that we can, obviously mention any specifics because we're not reaching those decisions. So this is move to direct the Planning and Zoning Commissions to make factual that any of their factual findings must be supported by substantial evidence. That's stated correctly?
Yes.
Is there a second to that?
before seconding
Second.
it,
Sorry.
would it be appropriate to also say that the summary of the community meeting must meet the minimum requirements of 2103.020C6D?
I think that's already included in our prior motion, a couple motions ago.
Okay, great.
So Member Laffey seconded. Any discussion on this? Hearing none, let's go ahead and call the vote on this one. A vote yes would be directing the Planning and Zoning Commission that their factual findings they make must be supported by substantial evidence. A vote no would not require that. Please call the vote.
Member Pease,
Yes.
Chair Rose,
Yes.
Member Lappin,
You cut out.
Yes.
Remember that. Okay.
Yes.
Okay, I don't believe there's anything else we need to discuss on this appeal today. I think that at this point, our attorney will draft up the draft conclusion, findings of fact, conclusions of law, and we will meet again on, it's not on the agenda.
through the chair, it's Wednesday, May 22nd from 10 a.m. to 11 a.m.
Wednesday, May 22nd at 10 a.m. To discuss the draft findings of fact, conclusions of law. I'm going to move on in the agenda then to, there's no old business, member comments, starting with Member Pease. Do you have any member comments?
No, I do not.
Member Laffey?
No, thank you.
Well, I'm not sure what that was. You cut out pretty significant there. Go ahead.
I have no comments, Mr. Chair.
Okay.
At this time. Thank you.
All right, I will also reserve on my comment other than to say it was nice that we were able to have the meeting. Thank you everyone for coming. Audience participation, if any members of the audience would like to speak, if you're online, go ahead and do the raise hand or icon. If anyone here wants to speak, you're welcome to just kind of raise your hand. I'll go through it. Reminder, no discussion about the decision that we just made, or anything related to that. But if you have any other commentary, feel free. So I'll start with the folks in the room. If anyone has anything, you're shaking heads. No. Okay. Anybody online want to mention anything for audience participation? No. Okay. In that case, I will entertain a motion to adjourn the meeting.
I move to adjourn.
Move to adjourn.
Okay, move in, so I'll
I'll
call that a
second
second. A meeting adjourned. Thank you, everyone.
Thank you all.
Thank you, everyone.
All right.
Mouse.